I'm going to zoom in to access to justice and especially access to procedural accommodations for persons with disabilities, specifically in criminal proceedings, mainly through presenting the ICJ's recent publication, the Model Disability Rights Benchbook. So it is a first benchbook of its kind across the EU, really covering both EU and international human rights standards, aiming to serve as a resource for justice actors on the rights of suspects and accused persons with disabilities in criminal proceedings. So it provides a general overview of international human rights law and standards, guidance on applying disability inclusive principles in legal proceedings, and especially procedural accommodations. And also it includes concrete recommendations for justice actors and also for legislators and policymakers. It's really aiming to ensure that rights of persons with disabilities in criminal proceedings are respected, and hopefully the benchbook is further used in various countries. We have actually drafted this benchbook as part of a project led by the Validity Foundation, and we were using information and research from national partners in 8 EU member states. And during the duration of the project with this Model Disability Rights Benchbook, also the national partners have been developing national benchbooks really adjusted to the national context in their countries. And perhaps important to say that the benchbook is looking at the rights of all persons with disabilities, but especially the rights of persons with psychosocial and intellectual disabilities. So really the main aim of the benchbook is to highlight the obligation of states under international law to ensure that all legal proceedings and processes are fully accessible to persons with disabilities, and that it is a state's duty to ensure effective participation of persons with disabilities in judicial processes. This clearly stems from the UN CRPD, that has been the UN Convention on the Rights of Persons with Disabilities, that has been signed and ratified by all EU member states and also by the EU itself. And so together with the general comments issued by the CRPD committee and also the UN International Principles and Guidelines on Access to Justice for Persons with Disabilities, it is kind of the main source of human rights standards on rights of persons with disabilities. At the EU level, these rights are equally covered, of course, by the EU Charter on Fundamental Rights and also several directives and recommendations. But in the same time, these are not really adequately covered, especially in the secondary legislation, in the directives, for instance. Of course, non-discrimination and some general principles are mentioned in the recitals, but we have also analyzed a bit more in the benchbook the EU legislation, which we find really inadequate and often not in line with the CRPD. In the same time as the EU has signed and ratified, and also all the EU member states, the UN CRPD, of course, there is an obligation to also apply and implement all the legislation in light of the UN CRPD. To present the benchbook, I will give first like a short overview of the International Human Rights Framework, and I'll mainly focus on procedural accommodations as described and recommended by the benchbook for the justice actors. So here are some of the key principles for access to justice for persons with disabilities. Autonomy. Persons with disabilities have a right to autonomously make decisions about how, when, or if to participate in justice processes. Individuality, there's a wide range of disabilities that persons experience, so each with unique impact on their ability to access justice. Fair trial, so international law does not require persons with disabilities to be exempt from accountability, which is often the case, and we'll see in a number of EU member states when it comes to lack of legal capacity and lack of the possibility to actually participate in proceedings. Finally, forced institutionalization or treatment on the basis of disability are not consistent with the rights of persons with disabilities. Just briefly regarding the definition of the CRPD on disability, it says it's produced by the interaction between an impairment and the barriers in reality faced by persons with disabilities in society. So disability is described as an evolving concept. And while it can be often challenging to identify disability, this always has to take place on an individual basis. And as Ruth has already mentioned, it is the obligation of the justice actors or of the interlocutants to make sure the persons are, for instance, understood and the communication is enabled. So also, as Ruth mentioned, access to justice is embedded in Article 12 and 13 of the UN CRPD. It provides for equal recognition before the law for persons with disabilities, explicitly stating that persons with disabilities enjoy legal capacity on equal basis with others. And it obliges member states to ensure effective participation of persons with disabilities in all legal proceedings. There are various types of barriers that persons with disabilities have to face in society, and states have the obligation to eliminate them. Some of the main ones, some of the legal obstacles especially that a number of EU member states are still using nowadays are, for instance, guardianship, which typically gives one person a full legal capacity over another, which then effectively strips this person with disability of their right to make decisions. And I think this was also already mentioned by Ruth in her presentation. Once this is established, it's typically quite impossible to remove, as the individual who has been deprived of autonomy would have to prove that they have the capacity to act on their own behalf. And the concepts of standards such as unfitness to stand trial or insanity defenses are discriminatory and are in violation of the CRPD. There has been, for instance, a case, Medina Vela versus Mexico, in front of the UN Committee on the Rights of Persons with Disabilities, where the committee exactly found a violation of Article 12, where the state denied a person with disability their legal capacity. They were not able to plead guilty, not guilty. They were not able to design a lawyer of their choosing or challenge the evidence. So when it comes to the procedural accommodations, because of the existing barriers, persons with disabilities will often not participate in legal proceedings fully, and therefore we need procedural accommodations to allow for that effective participation and full realization of the access to justice. So this is stated in the Article 12 CRPD, and they must be individualized, appropriate, and based on the person's will and preferences. And justice actors must proactively identify the needs of the person concerned. I will mention a few concrete examples of procedural accommodations, as we also describe them then more in detail in the Benchbook. So first, intermediaries or facilitators that are typically appointed and employed by the court and are kind of neutral facilitators or intermediaries in the proceedings in principle. So they are there to facilitate communication by and with a person with a disability during the proceedings. And yeah, typically they're used in justice system, for instance, in the UK. And some EU member states have also started to use this procedural accommodation, such as Spain or Romania. Second, a support person. It's usually someone who accompanies the person with disability throughout the process. It can also be a relative or a friend. And they also offer practical support to facilitate communication and provide adequate accommodations, but usually they are kind of next to the person with disability and they are really there to support them throughout the process. They're also explicitly mentioned in the international principles and guidelines. Third, I would mention a wide range of procedural adjustments and modifications that can be done based on the needs of the person in question. So international standards provide a wide range of examples of what could be put in place, and also there's further guidance on how to do it. So for instance, adaptation of the venue, appropriate waiting spaces, removal of formalities such as cloaks or wigs, adjustment of the pace of the proceedings, having separate building entrances, modifications of methods of questioning, or the use of pretrial video recording or of evidence or testimony. And when it comes to access to information, but also procedural accommodation, there's a set of other tools to be used in the justice system based on, again, individual needs of each person. So there could be a sign language interpretation, accessible websites, amplification devices, using the Braille writing system, or facilitated communication. Just a note here, I've put up actually the EU recommendation. There is an EU recommendation on procedural safeguards for vulnerable persons suspected or accused in criminal proceedings, which actually refers to rights of persons with disabilities in proceedings. You can also see it is a recommendation, not a legally binding act. It's not a directive or a regulation, unfortunately, but actually it says that persons with disabilities should receive, upon request, information concerning their procedural rights in a format accessible to them. So for us, definitely this is in violation of the UN CRPD and the legal framework applicable at the international level to persons with disabilities. And we've been quite critical also of the EU standards. So again, as I mentioned before, the UN CRPD kind of lens always has to be applied also for the EU or national standards. So this was some kind of a snapshot of some of the procedural accommodations that we describe in the Benchbook, and we have also put together quite an extensive list of recommendations, both immediately relevant for justice actors and also further to potentially lead to changing the national legislations. So as for the practical recommendations, we suggest that justice actors should interpret existing laws and policies consistently with the CRPD. Once it is binding the country, the legislation should be interpreted in light of it, as I already mentioned. Every person with a disability has the right to make choices for themselves and should have access to all the relevant information and support that they need. There should be safe, fair, and effective engagement of persons with disabilities in the proceedings and the possibility to fully participate. There should be some kind of a practical mechanism to identify disability early in legal processes through some kind of an individual assessment. I didn't speak about it too much, but this is a big issue that basically disability goes unnoticed or not unidentified in the proceedings, and therefore also proceedings are not adopted. Where needed, there should be an intermediary or facilitator invited to assist the court, and persons with disabilities should be informed of their rights, especially to be accompanied by a support person, or other adaptations should be made. When it comes to the systemic recommendations, in many countries, national legislation has to change in order to be fully in line with the UN CRPD. And so first of all, to recognize and assume a full legal capacity of the rights of persons with disabilities to participate in all stages of the proceedings in all courts. Also, procedural accommodations should be specifically included in national legislation, and also the rules of the courts should ensure full implementation of the CRPD in the justice systems. And as I mentioned in the beginning, in some cases, the bench books that were already developed at national level could serve the courts in some of these countries as a kind of a practical tool to really adapt the proceedings. And finally, there needs to be systematic training provided for all justice actors on the rights and on communication also with persons with disabilities. And so just to say, the bench book is more general. It applies to all persons with disabilities, not just children, and it focuses on criminal proceedings and defendants specifically. So as you can imagine, for children with disabilities, the situation is often even worse. And Ruth was especially speaking about the lack of access to the right to be heard and to participate in proceedings. That is really prevalent, and it's even more more the case for children than it is for adults. Often we see children being seen more as passive kind of objects of protection rather than actually right holders, and that goes even more, that is even more true for children with disabilities. So there's also really a huge lack of existing procedural accommodations for children. And the national and EU laws are in breach often of the UN CRPD and also the UN CRC. So I think, like we've also seen throughout our work, that the crucial issues to focus on are early identification, accessible communication, and meaningful participation. And of course, not a lot of work needs to be done. So yeah, that's also probably a goal of most of us here in the webinar. So thanks a lot.